Tiam.
Mr. Deputy Speaker, please allow me to first wish all our Muslim colleagues Selamat Berpuasa at the start of Ramadan. The Criminal Law Reform Bill seeks to amend the Penal Code and bring it up to date. The Penal Code, as mentioned by many colleagues, is an important piece of legislation in Singapore, as it consolidates laws that relate to criminal offences. First enacted as the Strait Settlements Penal Code in 1871, the Act has been reformed on numerous occasions to bring it up to date. In recent decades, 1973, there were enhancements of punishments to curb the use of violence by criminals. 1984, the introduction of more deterrent punishments for certain offences. 1998, enhanced punishments for the abuse of domestic helpers. And 2008, a decade ago, amendments to expand the scope of offences. Today, we are here making further important amendments to the Code. This is the result of 2 years of discussion by the Penal Code Review Committee, or the PCRC. There were 169 substantive recommendations. After the recommendations, there was engagement with more than 700 stakeholders, with submissions from over 60 individuals and organizations. I applaud the committee and the ministries for undertaking this much-needed review. There has been robust consultation and the taking on board of suggestions and feedback. As the bill involves many changes, which many of my honourable colleagues have already covered, I will confine my speech to 2 particular areas which I had previously raised in the House. First, on gender neutrality. In May 2016, I highlighted that our current penal code was not gender neutral and made a request to the Ministry to consider reforming our penal code. This was in relation to the case of the April 2016 PP versus Zunika Ahmed. In this case, she was acquitted by the High Court of 6 charges under Section 376A 1 sub B of sexually penetrating a 13-year-old in a landmark decision. The case was subsequently heard in appeal before the Court of 3 judges. The Apex Court overturned the High Court decision. The Honourable Chief Justice emphasised at the time that Section 376A was to be gender neutral. While the Court has recognised the gender neutrality of Section 376 as it stood at that time, I am heartened that the PCRC has also proposed amendments to Section 375 and 376 so that the definition of rape would include non-consensual penetration and mean that men can be victims of rape as well. It also expands protection to cover a victim that is an adult male who is forced to engage in penetrative sex against his will by a female perpetrator. This brings the statutes up to date and affords men, especially juveniles, protection. We do not as yet have such confusion in our laws that have led to unbelievable circumstances elsewhere, such as in the 1993 case heard before the court in Kansas in the United States. Hermisman versus Sayer was a pivotal case in the US, where a woman convicted of statutory rape of a minor and was pregnant as a result of the act later successfully sued to claim child support from her victim. It is hoped that such a situation would never arise in Singapore. Second, with regards to child abuse material. I raised a question in April 2017 to ask if the Minister of Home Affairs will introduce specific laws on child pornography. I'm glad that the public consultations show broad support to criminalize non-fictional child abuse material. The new section criminalizes non-fictional child abuse as well as fictional child abuse material where it's indistinguishable if the child portrayed is real or fiction. The punishments are hefty, and rightfully so. A term of imprisonment which may extend to 10 years and liable to fine and to caning for using or involving a child in production of child abuse or producing child abuse material under 377BG2 and BH2. Term of imprisonment which may extend to 7 years and liable to fine and to caning for distributing or selling child abuse material, as well as a term of imprisonment which may extend to 5 years and liable to fine and caning for advertising and seeking child abuse material. However, Child abuse material should be abhorrent in whatever form it takes, whether it's non-fictional or fictional, and I add whether it involves a real child or a virtual one. The law seeks to recognize the special harm and depravity inherent in child abuse material and child pornography. As such, any material in any form should be considered equally abhorrent for its intent. Therefore, I ask that the Ministry consider including the criminalization of all fantasy or virtual child abuse material, which is what is usually termed as non-photographic pornographic images of children, or NPPIC for short. Criminalized NPPIC should include, but not be exclusive to, cartoons, animations, and drawings, even if they are not indistinguishable that the child portrayed is real or fictional. We will not be alone in this. Section 62 to 68 of the UK Coroners and Justice Act, Sections 1466A, A sub 1 and 2 of the US Protect Act, Section 1 sub 17 of the Thailand Criminal Code Act, the UNHCR optional protocol to the Convention on the Rights of the Child in relation to the sale of children, child prostitution, and child pornography also refers to child pornography as any representation by whatever means of a child engaged in real or simulated explicit sexual activities or any representation of the sexual parts of a child primarily for sexual purposes. Existing legislation is not as robust. Sections 6 sub 1 and 2 of the Undesirable Publications Act only imposes a conviction for a first offence of a fine of $2,000 to an amount not exceeding $10,000 or to imprisonment of a term not exceeding 12 months to 3 years. The same is so for the Films Act. The late Dr. Victor Klein, who was professor of psychology, did in-depth research into sex addiction and pornography. He describes 4 stages of sexualization: addiction, escalation, desensitization, and actualization. His research shows that those addicted to pornographic materials will want and will seek more explicit or extreme material and likely end up desiring to act out what they have seen. Just earlier this afternoon, Minister Ong Ye Kung also alluded to the normalization of behavior with availability of obscene material online. Minister Shanmugam also spoke in his opening of the second reading that the inclusion of material where it's indistinguishable whether the child is portrayed as fictional or non-fictional is to remove the defense by any accused that the material that he or she has been caught with is fictional. Therefore, shouldn't it be the case that all child abuse material, in whatever form it takes, should be criminalized? I therefore believe there is fertile ground to include all child abuse material as I have described, because technology will make it ever harder to distinguish real and virtual, as well as the psychological correlation progressing from virtual to real consumption. Therefore, although I believe that the amendments to the Penal Code as proposed under the Criminal Law Reform Bill are much needed and have been robustly discussed, I ask that my proposal to criminalize all forms of child abuse material, including NPPIC, to be considered. Notwithstanding my comments and proposal, I support the bill.